Good morning, everybody. I hope you can hear me. Welcome to the third in our series of Working in Australia webinars. Today, we are going to spend most of our time covering a further immigration update. You might recall, if you were present, that we did an immigration update a couple of months ago, but we're going to do another one today because it's a pretty fast-moving area with a lot going on. Prior to that, I'm going to spend a few minutes on payroll compliance, which actually will be the next session that we do next month. But I just want to spend 10 minutes on a few things there as well, which may be relevant to some of you, and a bit of a precursor to the session that we do next month, as I said. And as you can see on the slide, the agenda then rolls into a number of really critical immigration areas, given the complex environment that we find ourselves in and the world finds itself in at the moment. So I think it's going to be a really informative and insightful session. The way we like to do these things is present in a fairly informal fashion, might be 45 minutes or thereabouts, and then we've got plenty of time for Q&A at the end. So from our housekeeping perspective, you have the opportunity to submit questions as we go through on any of the topics that we cover. And what we will do is at the end, we will work our way through the questions as best we can. Now, what we find sometimes is that the questions require more time and thought and information than we're able to deal with in a simple question answer, but we'll certainly discuss all of them. And if we need to take some of those questions on notice and have a private conversation, one-on-one conversation with whoever's asked the question, then we're more than happy to do that as well. But we will try our best to deal with any questions as they come up. So by way of introductions, my name is Ben Renshaw. I lead our expat and employment taxes practice based in Melbourne, although I'm in Sydney today. I've been a partner with BDO for a few years now. With me, I've got Jockel and Rebecca Thomson, who form the key part of our immigration practice, who also sit in Melbourne but work nationally too. And between the three of us, we think we've got a pretty good session to work our way through today. So I might go next slide there, please. So as I said, introductions, you can see us there. I think hopefully some of you know us quite well, but we're more than happy to deal with questions either now or later. And I think you have our contact details from the most part from the invite, so do feel free to ask any questions, as I said, either now or approach any of us after this session or for any sort of discussion that you'd like to have. So what I want to do for the first 10 minutes, I'm really hijacking what is largely an immigration session here to talk about partly, as I said, a session that we're going to run. It says March there, it's not in March, it's actually in May. That is my fault. However, a session that we're going to run next month on pay compliance and year-end matters. Now, there's 4 areas here that I just want to touch on. That what we're finding is there's a huge amount of activity, be it audit activity or client activity in these areas, and it's something that I think is going to ramp up between now and the end of the year, and then into the next year. We're going to see lots of, I think, issues, concerns, focus, media around these topics. So I'm just going to spend a couple minutes on each one in turn before we get to the real meat of the immigration session today. So the first one I want to talk about really quickly is superannuation obligations. Now, superannuation is really interesting at the moment. There was an amnesty period set out by the ATO, which was quite a long period that ended in September of last year, where the ATO said, if you've got historical or current underpayments of superannuation, bring them to us. Voluntarily disclose them, we will help you fix them, we will be very kind, we won't impose any penalties, we'll be very kind in terms of admin fees and those sorts of things, because what we really want to do is help organisations get the right amount of superannuation to their employees' super funds. So they had an amnesty period, which is pretty unusual. The ATO don't normally go down an amnesty path. It's not an approach we've seen from them too much, but it's what they did last year. And a lot of people did utilise the amnesty period and did review and get caught up on their superannuation. Obviously, the challenge was that the period that the amnesty ran for was right in the thick of COVID. So where clients may have been, where organisations may have been focused on getting things like super right, actually they were focused very much on survival and JobKeeper and all those sorts of things, which I think meant some absolutely did use the amnesty period, but plenty just didn't find the time to do it. Now, as part of the legislation around the superannuation amnesty, what the ATO said is that we're going to give you this window to correct things, and we're going to be nice, and we're going to be kind, and we're going to help you do it. But if you don't avail yourself of that period, then a couple of things are going to happen. Once that amnesty period is ended, you can expect us, the ATO, to become more aggressive on these things and start to audit more. And then when we do that, you can expect us to be more aggressive and to apply bigger penalties and to not be as keen or to remit penalties as we might have been in the past. Now, the penalties for late payment and underpayment of superannuation, as well as interest, as well as an admin fee, as well as having to pay the superannuation to the ATO that you should have paid, the legislation actually provides for 200% penalties. So if you've underpaid $100,000 of superannuation, then you could potentially expect another $200,000 of penalties on top of having to pay the superannuation, which is pretty damaging, right? Superannuation is a big business expense, as it should be, but having 200% penalties in there is really problematic, especially in an environment where the economy is maybe, you know, some patches really strong, some patches not so strong. So what the ATO have said is, they said, well, we know we said that, we know we said we're going to be very aggressive on this stuff. We still intend to focus on superannuation. We still want to make sure organisations are doing the right thing. We will apply a bit more leniency around penalties than we said we were going to, because we recognise there are challenges in the economy. But that really only is if, the main thing, that really only is if you come to us. So you, organisation, voluntarily disclose any underpayments of super that you may have had, then we'll be kinder with respect to penalties. If you still don't do that, and we audit and we find problems, then you don't expect too much leniency. So the messaging still is, okay, the amnesty period's over, there's still some leeway with the ATO around penalties. It's still really important to get this stuff right now and off your own back, because if you don't in the ATO audit, then they're going to be quite aggressive with penalties. And what we're seeing in this space, to be a little bit more granular about it, is that, you know, super's complex, payroll's complex, organisations do make mistakes and errors, generally for the most part inadvertently, either in configuration of pay codes. That's a really common one, where a pay code has been set up incorrectly, should have been superable, but actually has been set up for whatever reason not to aggregate to super. So super's not been paid on maybe a bonus or a travel allowance or whatever it might be that's superable, and hasn't been set up properly. So that's a really common one. So we often get asked by organisations to do that review of the configuration of payroll to make sure it's been set up for super properly. And mistakes can really sort of roll up really quickly, because if it's a pay code that's been set up incorrectly and has been used a lot for the last 5 years, all of a sudden you could have quite significant underpayments of superannuation that need to be remediated. So that's a really common one. And then the other one is just broader process pieces where, with the best will in the world, superannuation has been calculated correctly, but payments haven't been made quarterly in a timely fashion like they should have been, and late payment of superannuation is problematic, not quite as problematic as non-payment, obviously, but still problematic too. So the message here is, even though the amnesty period's ended, if you do have any concerns around your super compliance, now is still the time to look at it and get those things ticked off. And what's more, even if you were sure it was right 2 years ago, things change, payroll moves on, payroll gets configured differently as new codes are added, or you move to a new solution, or a different payroll team or manager takeover, or whatever it might be. You need to, I think, to be constantly cognizant and aware that it's very easy for superannuation mistakes to be made in payroll that need to be sort of focused on and borne in mind, and if there are any issues, remediated before the ATO come knocking, to manage that as efficiently as possible. So the second piece I want to touch on, and the message is somewhat similar, is around payroll tax and state revenue office audits. So we're starting to see a real uptick in state revenue offices. As I said, I'm based in Victoria, so predominantly down there, but I know it's the same nationally for the most part. Really starting to look more closely at their own, really just looking at their own revenue streams and looking at where there may be gaps in payroll tax that are unexplained. And they're focusing on a few different areas. Contractors is a really common one. Are your contractors really contractors, or are they employees? Is question one, the gateway question, even if they are contractors. And the answer is often that although they're set up as contractors, they're not really, because they're doing the same thing as employees. They look like employees, feel like employees, smell like employees. Maybe they should be classified as employees instead. So that's the gateway question. But then even if they are contractors, there may still be payroll tax liability, and you have to then work through a bunch of exemptions to go, well, are they a contractor? Are they exempt from payroll tax? Have we applied those exemptions properly? So that's a really common area where we see state revenue officers focus. More broadly, they look at total wages reported. Does that make sense compared to the size of the organisation, compared to what's been reported to other people, potentially for work cover, for example? Does that match up? If you're reporting more for work cover than you are for payroll tax purposes, they may be interested in that, and I'll come back to that point in a second. Other couple of areas, FBT, they have access to FBT plans, FBT benefits been taken care of appropriately for payroll tax purposes, and the same goes for share plans. Have organisations dealt with individuals' earnings value from share plans in the right way from a payroll tax perspective? So they're the four areas that we often see state revenue officers look at. And what we're seeing is that when they have a sniff of a concern, they tend to look at everything. They don't tend to be particularly focused on what they want to look at, and they tend to look at an extended period. So if they've got a concern about maybe the rate of payroll tax that's been used, or the allocation between states even, then they may still ask to look at everything, contractors, FBT, assess all of those things for a 4 or 5 year period. As not as a fishing expedition as such, but just because that's their process, and they want to look at everything. So when you get one of those things, it can be quite a lot of work just to pull together the data and the information that's needed to respond, even if there's no issues. So the point there is, watch out for those things coming in. Certainly don't ignore them, and try and build the confidence you can build that what you're doing for payroll tax purposes is robust and does make sense, and that the information that you need you store in a way that gives you easy access to it 2 or 3 or 4 years in the future when it might need to be looked at. The theme with those two things, super and payroll tax, obviously, is the increase in audit activity. I think it's no galloping shock or great secret that the ATO feel like there's a hole, and state revenue officers as well, there's a hole in their revenue and the money that's coming in. They've got a bigger hole to fill post the JobKeeper in particular has been expensive for the government, of course. So I think we're going to see increased activity around trying to fill that gap where they think something isn't correct. The other thing that ties these two things together, and we've touched on it before and we may touch on it again today in this session, is that the ATO and the state revenue officers have an unprecedented access to data from other sources. Each other's data, state data, work cover I mentioned before, from a mobility perspective, immigration data, and a whole host of other things, which mean that they can get an early sniff, and they can use their data tools to automatically review information they're getting from other sources to see whether it throws out any concerns or red flags or areas that they want to delve into. And that process is becoming much more high tech and much more automated. It's much more difficult, and they're much more likely now to pick up mistakes or errors or oversights than they ever were before. So the stakes of the game sort of rise, right? It's more important that organizations really get those things correct, because inadvertent errors are more likely to get picked up than they ever were before, and you need to stay on top of them. The third thing I'm going to talk about really quickly, and it's a topic that we'll do standalone at some stage, I can't do it justice now, is the ever increasing focus on whether employees are being paid appropriately against an award or an EBA, or against their fair work minimum wage for that matter. Wage theft was a real topic, flavor of the month pre-COVID. It was heavily talked about in the press. I don't like the term wage theft personally, because 99 times out of 100 it's an error or an oversight rather than an active desire by an organisation to not pay employees appropriately. But the real message is awards and EBAs are complicated, and paying employees correctly against them is a complicated matter that relies on understanding the EBAs and having payroll and payroll processes configured in a way that makes sure that you're able to pay people appropriately against the award or the EBA, and critically making sure that your time and attendance methodology and system and process is such that you can capture the information that you need to really make sure you are paying people properly, that you understand when people are working overtime, you understand when they're taking breaks, you understand what's happening on public holidays and weekends and those sorts of things, so that you can have that data to then apply the rules under the award through payroll to pay people appropriately. So getting those things incorrect, as we've seen many examples in the press over the last couple of years, from a PR perspective, can be hugely problematic and challenging. It's not an activity that anyone wants to have to undertake and remediate, because the press is poor and reputationally, and the damage it can do on the employee trust and all those sorts of things can be hugely problematic. But we are seeing more activity from Fair Work. Unions are obviously interested as well around looking at these things, and it really started in hospitality and retail as much as anything. But what we're seeing now is all organizations across a lot of different industries are almost nobody's immune. So we're seeing investigations in education, not-for-profit, manufacturing, as well as retail and hospitality. Now, Fair Work did tread a little bit lightly during COVID. They understood that there was some existential challenges that were facing some of those organizations, but still they're doing their work in the background and it will ramp up again. So getting that right, I think, is really important, and it's something that if your board or your senior executive management and leadership aren't asking about as to whether we're covered, then they should be, and soon they will be. And even if you're pretty confident that you've got things where they need to be, I think being able to check that periodically and tick it off is a real valuable thing to be able to do, just for when the question does inevitably get asked. The last thing I'm going to touch on really quickly is share plan reporting. Now, it's reasonably straightforward, but also reasonably frequently missed. If you have taxing points that come about in the year as a consequence of either vest or exercise, typically these days, of a share or option plan, then there's a reporting obligation that sits outside of payroll that you have to meet to the ATO by July 14th and to the employees by August 14th, so that ESS taxable amounts can find their way onto tax returns appropriately. It's not the most complicated process in the world once you understand which of your employees have hit a taxing point, and you understand how the share or incentive or option plan that we're talking about works for your organization. Once you've got those things, the reporting piece is easy, but it does get missed quite frequently. If you've got complex plans, or you've got execs in more than one plan, and that maybe grants have gone back a few years, if you've got employees who are perhaps cross-border employees and have come to Australia or left Australia partway through a grant to vest period, all those things sort of increase complexity in the ESS reporting world, and it's something that I think from a year-end perspective, organizations have to get a good handle on, partly because it sits outside of payroll, right? So there is a bit of manual process there. It's not covered by single touch payroll in the same way as regular year-end reporting is. So it's just something not to lose sight of. So listen, they're the four things I wanted to touch on really quickly. I think I've probably already gone over the time I said I would. I'm going to spend much more time on these things in our upcoming session, 18th of May, not March, as I said in my error, and we'll make sure that invitations go out around that, the topic in a bit more detail for that date. So I'm hoping that some of you, if it's of interest to you, might join us for some of those things. Happy to spend as much time as necessary on those four things in particular. And if you've got questions today, we can deal with them at the end. We might hold them over to the next session, but feel free to send them through to us if you like. But otherwise, I think that's everything that I intended to say. So I think from here on, we're going to get to the meat of the session, which is the immigration piece, as I said. So I think I'm handing over to Maria from here to walk you through those pieces.
Thank you, Ben. Good morning or good afternoon, everybody, and welcome to this session. I lead BDO's incorporated law firm, and we work synergistically with people like Ben Renshaw in the tax and compliance and related areas. In terms of today's webinar, we're going to be covering a lot of ground, and we've got a limited time available. But I think that anyone who works in this jurisdiction or wants to take advantage of Australia's immigration laws needs to be aware of its complexity. We certainly have the most complex immigration laws in the world, over 3,000 pages of legislation, underpinned by over 50,000 pages of internal policy guidelines of the Department of Home Affairs, which we get under licence. There are some 99 visa categories. Today we'll be touching upon only 3 or so to give you some insight in regard to the calibration of the migration program. Insofar as the transformation of the management of Australia's borders, we should all be aware that we are dealing with a completely new regulator, which is part of the Home Affairs portfolio. This portfolio continues to transform as part of a whole of government approach, which is focused on dealing with the complexity of the global and local environment and the incredible and ongoing demand for temporary and permanent entry to Australia. As a result, particularly during this period, Australia continues to implement a highly restrictive reform program, and with a particular focus on compliance and regulation. And it also is using targeted migration, skilled migration and business employment migration as part of an economic recovery. So that's a broad context. That of itself lends itself to a one-hour seminar because it's simply skeletal. Next slide, please. Now, everyone is aware of the economic impact of COVID-19. We've had the greatest economic shock since the Great Depression. The government has embarked on enormous economic stimulus, as a result of which, in effect, the Australian economy has been enabled to progressively rebound. But the reality is that we've got a national debt which is estimated to be 1.298 billion in 2023-24. This morning there was some positive news about the fact that the mining sector may result in a better response in terms of the bottom line than was otherwise expected. But we all in Australia have had the benefit of the JobKeeper, JobSeeker and other health and economic support packages which have been integral to where we are today. In addition to that, the government's continuing structural reforms. There's a focus on protecting and creating jobs and training. There's investment in advanced manufacturing, infrastructure, digital tech economy, health research and development, and other matters which are driving Australia's economic recovery. And this is all relevant to the next slides that we're going to be talking about and how this is impacting on Australia. Now, with the closure of Australia's borders, the historic reliance upon migration for population growth is no longer available to us. We are now experiencing zero population growth, and that obviously is having an economic benefit, economic impact on us also. And insofar as the current migration program is concerned, in effect, it is not at all contributing to our economic growth. It is anticipated that this is also impacting on a number of people who can have their visas approved, and Rebecca and I will touch upon these matters a bit later. This is expected to increase to around 201,000 in 2023-2024, but at the moment, anybody who's trying to make the best of what the migration program in the current environment offers will need to consider the government's priorities, and we will be touching upon these today. And it's your employer sponsored, it's your global talent, and your business innovation and investment visas. Next slide, please. So with the closure of the borders, we all know that we've got a rather paradoxical situation. We've got nearly 1 million Australians unemployed, and we've got about 1.7 million temporary visa holders in Australia. And paradoxically, we have a skills shortage because, of course, with the opening of when our borders are open, there's a much more easy basis upon which we can get skills into the country, which is currently not the situation. So certainly the interim report into the inquiry into Australia's skilled migration program, which was delivered in March 2021, has noted this, and comments being made by chambers of commerce, including, for example, the Chamber of Commerce and Industry in Western Australia, have noted that this is impacting on business confidence because businesses have identified skilled labour shortages as the largest barrier to growth over the coming year. And this is also confirmed by the ABS, which is basically showing that there's been an increase in job vacancies relative to last year of 13.7%. New slide, please. All of this, therefore, has an impact on what's going to happen moving forward. But the reality is that the migration program continues to be part of Australia's economic recovery plan, albeit calibrated somewhat. The planning level remains at 160,000 permanent places that are available in this financial year. The focus is on the Global Talent Independent Program, which has a historic 15,000 places. Business Innovation and Investment, which has a historic 13,500 places, and the employer-sponsored program has been reduced to 22,000, a reduction of 26.7% to last year's quota. It's also very relevant to note that as at the 31st of December 2020, there are some 600,000 less temporary visa holders in Australia compared to that same period in 2019. and there's a progressive reduction in the number of visa grants for temporary skilled residents. Next slide, please. This particular slide depicts the 2020-2021 migration program. Those of you who are viewing this, you will see that in the right-hand side, compared to last year's planning level, there's been a significant reduction across the board because of the fact, let's face it, the government's focus has been not so much on processing visas, it's been on protecting Australia, keeping us safe, and allocating significant resources to the circumstances in which somebody who's outside of Australia can enter Australia. Next slide, please. This slide also shows the reduction in the number of temporary visa grants in this period that we're living through at the moment. Again, there's been a significant reduction. Just the number of visitors that are not coming to Australia is 3 million less, etc. So all of this is, there's fewer working holiday makers, obviously, because if they're not in Australia, they're not going to be able to come in on the basis of the fact that they want a working holiday visa, and so it goes on. Next slide, please. So what opportunities are there for Australian businesses to take advantage of the government's economic focus? One of the things that we're very much aware of is this. If you're going to try and get a visa for anybody who's outside of Australia, you're completely guided by priorities of the government of the day. One of the things that gives us an indication as to government priorities is the industries that the Australian government considers to be critical. Now, whilst these are critical industries are relevant to determining whether you get a travel exemption, assuming that you're coming here on a skilled visa, nonetheless, they give you an insight as to what the Australian government considers to be a critical sector where there are no Australian workers available, and that includes obviously medical specialist services, but it's also areas such as medical technology, critical infrastructure, telecommunications, engineering and mining, aged care, agriculture, food production, and sectors of industry which are critical to Australia's economic recovery, including financial technology, large-scale manufacturing, and emerging technology. So if you happen to be in a business which may be synergistic with one of these critical sectors, this may offer you an opportunity to create a visa solution. Next slide, please. This slide is indicative of how difficult it is, for example, currently to get travel exemptions approved. This is inward travel exemptions to Australia, and it gives you a snapshot of time over a 3-month period. But in terms of the total number of applications that were lodged, which was some 87,000, in effect, 14,000 odd were approved. So your refusal rate is pretty high. And again, this indicates this is another way of identifying for you how specific and targeted you have to be in any strategy that you adopt as a business in terms of trying to get your workers into the country if they're offshore, but also understanding the challenges that this presents generally in terms of getting travel exemptions approved. We are pleased to tell you that we've had a 99% success rate insofar as our travel exemptions approval is concerned. Next slide, please. So again, in the context of critical industries and travel exemptions, what does that mean for people in Australia? Well, we know, for example, that people are getting an emergency visa. It's called the 408 visa. If, for example, they're working in sectors which the government considers to be critical sectors during the pandemic. Now, this is a mechanism for people who are currently in Australia, and I touched upon the fact that there are 1.7 million people in that temporary visa holder, and there's about 500,000 international students who hold 500 visas. A lot of these people are looking for a mechanism to try and stay, and some of them may indeed be eligible for this 408 emergency visa. It's really it doesn't necessarily lead to other opportunities, but it does give people an opportunity to stay in Australia if they are going to be working in a critical industry during the pandemic. And remember, the pandemic is an evolving issue. We've just seen what's happening in India, and this is going to have presumably a ripple through effect on Australia. But the critical industries in the context of this particular emergency visa, the 408, include agriculture, food processing, healthcare, aged care, disability care, childcare, and for those particularly who are student visa holders looking for a mechanism to work in excess of their normal work rights as holders of a subclass 500 visa. There are critical industries which can permit them to work in additional hours, including health, aged care, disability, and agriculture. Now, this is a tiny snapshot of a particular area. It is not a focus area, but it may be of some utility to anyone who may be listening or to your business operations. Move on, please. Again, the government continues to calibrate the migration program, and in the context of not only travel exemptions, but the 482, 494, 186 and 187 visa programs, the government in October 2020 created a new list of occupations. Any of you who are familiar with Australia's migration laws would be aware that we have multiple lists of occupations which are appropriate according to what visa category may be considered at the relevant time. But in addition to the current 482 the temporary skills shortage list, the skilled employer-sponsored regional provisional list, the employer-sponsored 186 list, and the regional sponsored migration list, that's the subclass 187, we have this once-off priority migration skilled occupations list. Why is it relevant? Well, if your candidate is offshore and they can claim this occupation and you otherwise meet the requirements, that candidate can be eligible for a travel exemption so that they can fast track their entry to Australia, because the Minister has also issued a directive to say anyone on a priority migration skilled occupations list occupation will be entitled to priority processing of their visa applications at a time when many visa applications in this category of visas are languishing because they do not fall within the current economic priority areas. So what this means is that the government has allowed for a small number of skilled workers to be sponsored to enter Australia, or if they're in Australia, to be sponsored for one of these visas, because it's perceived that these occupations will help create jobs and rebuild Australia's economy. Now, again, as I said earlier, I said there was about 1 million people unemployed in Australia. Well, it's pleasing to know that it's being reduced. As of February 2021, there were 805,000. I don't have the current data post the cessation of JobKeeper, but we have some 1.7 million temporary visa holders in Australia, and clearly the Australian government is not focused on giving those people work rights and permanent residency if they do not fall within the priorities of the government at this time. Move on, please. So the priority migration skilled occupations list is a select group of occupations, but they do get priority processing. And as I said earlier, if they're offshore exempt from Australia's travel restrictions, they still have to apply for them, but they're able to get pushed through if they can meet all the evidentiary requirements. And it includes a chief executive or managing director, construction project manager, mechanical engineer, general practitioner, resident medical officer, psychiatrist, a midwife, a registered nurse in the aged care sector, a registered nurse in the critical care and emergency sector, a registered nurse medical, a registered nurse mental health, a registered nurse perioperative. This is really a focus on the healthcare sector, which is obviously obvious in the context of COVID, a developer programmer, a software engineer, and a maintenance planner. Now, if you're not one of those, then you're not a priority occupation, and therefore you can't take advantage of this particular government initiative. Move on, please. In addition to the fact that we've now got this priority skilled occupations list, we've also got enhanced labour market testing. And this particular slide talks to the fact that obviously we now need 3 advertisements, including Job Active, as well as, for example, Seek or one of the other advertising platforms. They must be, these 3 advertisements must be run for all at the same time for a consecutive period of not less than 28 days. And at the end of the day, if you're able to have evidence with efficacy and cogency, that there are no suitable Australian qualified workers available for the job, and of course at the relevant salary and in respect of this particular position, which is detailed in the advertisement, then you may find that your Australian candidate, be they onshore or offshore, may be eligible for the job. So this is really, again, intended to safeguard Australian jobs. And at the end of the day, unless you've forensically complied with the labour market testing requirements and you lodge a nomination application, you can expect it to be refused. You will forfeit your Skilling Australian Fund levy, and it is quite likely, therefore, that unless your visa application is withdrawn, that will obviously have to be either withdrawn or that will be refused. Move on, please. Now, I think I need another one besides that one, but in any event, I can find my own place on my hard copy. And yes, thank you very much. We'll move on to skill shortages. What can you do? At the end of the day, we have to appreciate that COVID is continuing to dramatically impact on not only the government, but on public perceptions. Everyone wants to do the right thing, and everyone wants to ensure that Australians are the first to get the job. So therefore, how do you act with efficacy so that you as a business operation, big or small, can meet what you need to do to continue to thrive in an increasingly challenging world, be it local or global? You must get expert advice. We have the most complex laws in the world and they constantly change. As part of the government's ongoing transformation of the management of Australia's borders, we lawyers, such as myself and Rebecca and our legal team, have been released from dual regulation. We are no longer migration agents. We're considered to be lawyers proper, as we always have been, and indeed I'm an accredited specialist. You need to get it right, otherwise the application will be refused or will not be processed. It may languish there for a significant period of time, which is not a good idea, because you may find that with the changing nature of the priorities, that application ultimately may not have the maximum chance of being approved. You need to consider what is the correct occupation. You cannot morph something and create something which is not true, because we're going to run a series of webinars on risk and compliance, where we're going to give you lots of touch points as to how things can go wrong for you in this world of data matching. You need to know about labour market testing. Have you met the forensic requirements? And I'm using the word forensic decidedly. You need to know who to get advice on, from when and on what basis, and how this can basically be used strategically to meet your business needs. You need to accept that there's a constantly evolving new normal. It is constantly evolving. Just what's happening in India at the moment is likely to have an impact on travel exemptions and people being able to fly internationally from certain parts of high risk in the world, because the Australian public expect the Australian government to make our health the #1 priority. Let's move on. This creates formidable challenges for each and every one of us, but it also creates enormous opportunities, because with the right advice at the right time, every employer of high calibre should be able to address skill shortages. And an example of how the government continues to calibrate the migration program is the fact that it recently amended its internal policy guidelines. You may recall in my first slide, I referred to 50,000 pages of internal policy guidelines, which we have access to under license. Relevantly, there is now a whole, the equivalent of about 1 page of new policy, and we've just got the essence of it here. But at the end of the day, anyone who's going to be lodging a 186 or 187 employer-sponsored permanent residency visa for the nomination application must evidence heightened requirements as to whether there is truly a genuine need of the overseas worker. Those of you who previously have worked in this industry would have known that if you had a 457 and you'd been on that visa for 3 years, you had basically, in effect, an expectation that you'd be eligible for a permanent residency visa. There is now, however, a new focus. The employer must show that there's truly a genuine need for that overseas worker. Have they tried to recruit to the position? What have they done in that context? And remember, the government's Job Active website is their website. They track and analyse the data of all ads which are lodged on that website so that they can use it to inform them in regard to those positions that might be considered to be subject to skill shortage. All of this is part of the data which the government is using to continue to calibrate and refine the setting under which we can bring in and or retain overseas skilled workers. And the information that you provide in your nomination application, does it all hang in together? Because at the end of the day, as a business, you are providing an enormous amount of business data. All of that can be subject to a data matching protocol. We know that by virtue of the Home Affairs portfolio, and prior to that, that the Commonwealth has established a data matching processing centre where on a risk matrices basis, a lot of data can be analysed very closely, including whatever you lodged previously with the government. Move on to the next slide, please. So at the end of the day, when you're looking at your skill shortages, one of the things that the government is now saying to you, if you're going to be lodging a 186 or 187 nomination application, well, who have you made redundant? Who have you made retrenched? Who have you retrenched in the last 12 months? Whose pay have you reduced? In what way have the conditions changed? Are you employing an overseas worker where the conditions of employment, could I please have that slide again, please? Thank you. Where the conditions of employment are less favourable than what you would provide to Australians. I'm sorry, I think we're having a bit of trouble with that technology. Thank you. I'm sorry, I'm losing a bit of my slides. Excuse me while I get my hard copy. Are we recruiting a temporary visa holder beyond the ordinary scope of business? This is a very telling slide because it requires you to interface your employment risk with your visa risk, with your payroll risk, with your single touch payroll, with the entire amount of data that you give to government in disparate ways, and take account of what that means in regard to your ability to readily sponsor somebody under these visa programs. And remember, in our previous webinar, we touched upon the Enhanced Integrity Act, where the Minister can name and shame corporations which do the wrong thing, particularly if you recruit a, say, 457 or 48 visa holder in a nominated occupation. They're approved on that basis, but you employ them out of scope of what you're entitled to do, out of scope of what's permitted, or indeed that you underpay them, because that may all be picked up by the ATO and the Department of Home Affairs in their data matching protocols. Next slide, please. So again, at the end of the day, what are we doing when we're acting for any corporate, big or small, in the context of be it a 482 or a 186, 187 visa? You are required to demonstrate that there's truly a genuine need. And if there's been a significant economic downturn because of COVID, how do you justify the recruitment of overseas worker? Clearly, we've got a skill shortage. There's absolutely no doubt about this. But these are all mechanisms which the Australian government has seen fit to put in as things that you must be able to address appropriately so that the government can be satisfied that at the end of the day, you really need that person as a permanent employee of your organisation. And in that context, therefore, one looks at a range of other factors, including whether you're expanding your business, whether you're offering people overtime because you're trying to fill a vacant position and you can't, and all the other things that you're doing to attempt to recruit Australian workers to the position. So recently we spoke to one of our global clients and they've been telling us they've been trying to recruit to a position for 3 years. We've asked them now to give us all of their intelligence in regard to their attempts to recruit, because they're moving towards doing a 482 visa, and some of this historical data will be very impactful in terms of how we work with that client moving forward. Next slide, please. Again, we've touched upon 186 and 187 in terms of genuine need, but remember this is equally of utility to you if you're going to be dealing with 482 visas or a 496 visa, because at the end of the day, what you're trying to evidence to government is that you are an employer of high caliber and that you are undertaking all the things that you need to do. You're compliant with what you have to do as an employer. You've got an organisational business chart which shows what you're doing and the level of activity that you may have through the way that you present yourself. You've got ongoing business activity. You're showing that you've got ongoing volume and quality of business outputs. You'll be working obviously with your accountants and your payroll people, and you'll be doing things in conjunction with what you lodge with the ATO, including your BAS statements, your income tax returns and such like. At the end of the day, we're basically forensic specialist immigration lawyers. We see ourselves as your silent business partner. We're here to take a spectrum which isn't myopic. It takes into account every aspect of what the Department of Home Affairs, as a pivotal organisation which controls the border and who gets in, when and how, and when your visa is approved, what are they likely to be looking at? If one knows this holistic approach, then one is best able to ensure that every single visa that you lodge with efficacy is indeed approved, and that's what we pride ourselves on. Moving on, please. So, what's the new thing that the government has made as a top priority? Everything is being recalibrated. Now, interestingly, there was a very small piece of media news coming from Western Australia in regard to the fact that there had been an abuse of the program, which was a most unfortunate incident, and it's not much has been made of it in the public domain. But what happened was that fund managers and migration agents concocted non-genuine applications for Australian visas targeted at wealthy Chinese investors, and basically they were trying to take advantage of the what was previously called golden ticket program. Well, lo and behold, what happened was that resulted in a confidential internal review, and as a result of that, there has been a enhanced focus on the Business Skills and Innovation Program. Some of you who are already aware of this would be aware that certain states are not accepting certain visa categories under this particular program because they know of the forthcoming changes which are occurring on the 1st of July 2021. So basically, the program will be simplified in the sense that instead of having 9 streams, there'll be 4 streams, but that doesn't necessarily mean it's simplified. It means that the requirements will be condensed in a much more non-transparent way, in my respectful view, and it will be much more difficult to analyse exactly what are the trigger points that the government's looking for, but there will be the business innovation, there'll be the entrepreneur, there'll be the investor, and there'll be the significant investor. And as is not the case currently, except under the 132 business visa program, which is currently not even active, these will give a clear pathway to permanent residency for each category. So there will be a clear pathway. It will be very interesting to see what constitutes a clear pathway when we microanalyse them, thousands of pages or hundreds of pages or whatever it is of policy guidelines. In any event, as is clear, the premium investor, the significant business history, the venture capital entrepreneur visas will be closed to new applications from the 1st of July 2021. And so while this slide states that the applications already lodged will be processed, it will be very interesting to see how long it will take and whether in fact they are approved. Next slide, please. So clearly, what's the focus? Well, the focus is that the Australian government wants a higher calibre of business migrants with proven business skills, and they want higher assets, obviously minimum of 1.25 million up from the 800,000, an annual turnover of not less than 750,000 up from the 500,000 to show business acumen. And the previous visa that we had, where you could basically only require 200,000 funding to meet the entrepreneur visa applications, that's been scrapped. Now applicants need to be endorsed by their state or territory government. More and more barriers to entry, a higher calibration of the program for the best and brightest. Next slide, please. And this leads me to the Global Talent Independent Program. Basically, Australia, as I keep saying, what's the best and brightest? And so this unique one-off initiative, which actually has 15,000 places allocated to it in this financial year, is here to help Australia into a powerful magnet whereby individuals and enterprises who have got capital, talent, ideas and global networks will be permitted to come to Australia on a fast-track basis. Next slide, please. This is a pictorial depiction of the Global Talent Independent Program. I had the privilege of listening to the Prime Minister's ambassador, who's travelling the world and basically selling this program wherever anyone is interested. But basically, the individual has to be a highly skilled person, and they have to come from one of the targeted industries, which includes ag tech, fintech, medtech, cybersecurity, quantum information, advanced digital data science, ICT, space and advanced technology, energy and mining technology. And this really shows how Australia is trying to use the fact that we are the safest haven in the world with the greatest level of economic prosperity despite COVID, with a total commitment to the safety of our community, why we are a magnet for the best and brightest in the world. And we're indeed seeing this, where we're even getting people of ultra high net worth and high net worth looking at Australia as a safe destination or as a place to invest in, or alternatively local and global businesses reaching out and saying, how can we take advantage of these various programs so that we can one way or another grow our business and meet our operational needs? Move on, please. So with the Global Talent Independent, these are people who are independent. They're not having to be sponsored by anybody, but they've got internationally recognised standing and achievements in that particular industry. They're prominent in their field of expertise. They've obviously got evidence they're going to be an asset to Australia in that field of expertise. They'd have to evidence they can find employment in Australia, become established in Australia. They've got to be recognised by either an individual in the same field as that person or an organisation as having that talent, and they've got to have the ability to attract a salary of not less than 153,600, which is the high income threshold, and that's adjusted annually. So even before the Global Talent Independent Program was announced, we had the privilege of acting for a British inventor who'd invented something to do with, in the medical sphere, relating to insulin and diabetes. He was able to be fast-tracked to approval under what was the previous Distinguished Talent Program. And we now have a much more ratcheted one, which is the Global Talent. Previously it was 5,000 places, now it's 15,000 places. Spread the word. If you fall within any of these categories and you are forensic in the way that you go about making sure that you get through this system, then this is an opportunity for fast-track permanent residency. Next slide, please. So remember, everybody thinks that they're fantastic. University students might say, well, hang on a minute, I'm a global talent. But the reality is, and I started off with the complexity of our laws, everything lies in the documentation and how you readily meet from an evidentiary point of view, speaking as a lawyer, that you have a high standard and an exceptional track record of professional achievement, which can include senior roles, the fact that you've got patents, that you've got professional awards, that you've got international publications and memberships, that you're a master's graduate, that you're a PhD student, but somebody who's demonstrated exceptional talent and international recognition across one or other of the targeted sectors. Obviously, if you're a master's or university student doing a PhD, your threshold requirements may be more onerous to achieve if you haven't been in the industry already operating as a global talent, but everything turns on the minutiae of detail. I cannot under stress or over stress the word minutiae detail. Move on, please. Okay, now I'm going to hand over to Rebecca Thomson. Now, before I do, I want to commend Rebecca Thomson. She's our managing associate. She's got multiple qualifications and high-level skills. She's worked in and out of law and other industry sectors. She has an incredible attention to detail, and she undertook a forensic analysis of a lot of data which is available. You can spend hours and hours trying to connect the dots. Here's a mere little snapshot of some of the data, because once you understand how all of this labyrinth of rules and requirements works, and then you look at what data they've got in regard to monitoring and compliance, you put all of that into the wash so that you ensure that while your clients get their visa needs met, they are also compliant. And remember, Rebecca will tell you who does all the monitoring and compliance. So over to Rebecca.
Hello everyone, and thank you for your time today and for joining us. I'm just briefly going to touch on sponsorship monitoring and compliance, and like Maria has suggested, we've got an upcoming webinar series just on risk and compliance in this space. So despite the fact that there are less foreigners coming to visit our shores at the moment, the department still continues to undergo monitoring and compliance activities. So you see there's about half of what there was in the previous year, but it's still 8,000 dob-ins or allegations, which is people ringing the department or submitting a form saying we think one of these businesses is doing something wrong. So for example, with labour market testing, if you've got a disgruntled employee who thinks that they should have got the job, they could be filling in the department's web form and dobbing in the organisation. So it's really important that when you're thinking about it not just beyond each individual circumstance, but that whole compliance piece. So the department still continues to go and visit and do field activities. They continue to locate illegal workers, and they continue to have employer awareness activities. So that's when they might come out and do a site visit. They might do that just the Australian Border Force, or as we've had clients in the past, they also have the Fair Work Ombudsman meeting with them. So it's a combined compliance activity. And it's important, touching on what Ben said earlier in there, to think of it as this whole of government approach. Not just the Department of Home Affairs, not just the ATO, not just the Fair Work Ombudsman, but all of them coming together to ensure that employers are meeting their ongoing compliance requirements. The illegal worker warning notice is really when there is, I'll touch on it just briefly, it's about employers who are employing someone in breach of work rights. And what's important to note with the illegal worker warning notice, of which there were only 49 issued so far this year, but if you consider that the penalty is up to $315,000 or 5 years imprisonment, and that these penalties, because of the Employer Sanctions Act, can fall directly on board members and company directors, it's incredibly important that as a business, you understand what your ongoing compliance requirements are. It's just a snapshot of what's happening at the moment. It's a very small snapshot and there's a lot of figures, but what it shows is that overall, we have this focus on highly specialised skills and what are the critical industries that are aiding or considered to aid Australia's economic recovery? How can we manage brain drain and the closure of our borders and ensuring that we're getting top talent into Australia? There was a reduction, as Maria spoke to earlier, of 26.7% in the number of subclass 186 visas that can be approved this year. There's only 1,600 spots left between now and June if you're going to meet planning levels. So there's not much space left for grants because there was a very small number available. There's a lot of restriction on getting temporary visa holders into Australia. It's a limited opportunity. You have to have a phenomenal business case or be very compassionate and compelling circumstances. It's really incredibly complex at the moment, hiring and recruiting foreign workers. And you have to have careful consideration about what documentary evidence you require across the spectrum of visa programs, but also specifically with travel exemptions. 52% of those inward travel exemptions for non-medical critical skills were refused in the 3-month period. That means there are a lot of businesses who are applying for people to come and join them that simply can't get them into the country. So that's just a very brief summary. Maria will speak very briefly about our upcoming risk and compliance webinar series. I'll just pass it back to her.
Thank you very much, Rebecca. I would have loved you to have expanded on those points a lot more because I think they're all full of incredible messages. What is very clear is, and this is what we touched upon in our previous webinar, that we've got the Australian Border Force as the independent operational enforcement arm of the Department of Home Affairs. Insofar, and if you wouldn't mind going back into that slide, please, Rebecca, the previous one. Thank you. What we have is basically the Australian Border Force undertaking all the sponsorship monitoring and compliance activities. They are embedded in all aspects of the operations of the Department of Home Affairs, in addition to working independently and synergistically. As we said in our previous seminar, we've got the Commissioner of the Australian Border Force, who's equal in rank with the Chief of the Australian Defence Forces, who's been appointed by the Prime Minister as responsible for not only the closure of the borders, but for when a travel exemption can be approved either by the Commissioner himself or by one of his delegates. So as Rebecca has said, the number of the inward travel exemptions which are being refused, it may in fact reflect the fact that the calibre of the applications are not sufficiently strong to get through a difficult system where the Australian government must balance the public health needs and the safety of the Australian community against needing, for example, critical skills to come into Australia, against the fact that there are currently some 35,000 Australians still offshore looking for a mechanism to return to Australia at some stage or other. So when we're talking about a calibrated migration program, what we're inviting our listeners to do is to look at this in a different way to what you've done historically. Look at it more as a holistic, if you can, program where you try and put in the jigsaw pieces to create a picture of what's happening, so that, then move on please to the next slide if you would, Rebecca, so that in effect we can consider, well, you're a business, you're an individual, you want a visa, you want to make sure that that visa is granted to you. What are the risk and compliance aspects that you will not be aware of in this new environment? At the end of the day, if we're going to talk to employers, employers will know by virtue of the single touch payroll and the fact that in July 2022, company directors will have their own identity number, that the risk is a management process. It's strategic, it's organisational. It requires you to identify your risk. It requires you to analyse the risk, to treat the risk, and to basically ensure that your risk is managed. Just in the point that we made previously, you may be an employer who's who truly must have your overseas workers, be it on a temporary or permanent basis, but you haven't managed the labour market testing space very well, which has therefore impacted on your ability to be able to access the program appropriately, because simply, for example, you didn't meet your labour market testing. You did not micromanage or fully understand how that operates. Insofar as compliance is concerned, you're aware of the fact that all the information that you provide to a government agency and everything to do with immigration enables the Department of Home Affairs to collect an enormous amount of personal and business information. And that information, you may have lodged it some years ago, but it sits there, it's digital. It can be checked against what you do subsequently. How do you see your visa process as a continuum? How many clients actually have their full documentary evidence as to what was previously lodged on their behalf and what they wanted to build upon moving forward? How do you make sure that you haven't got any inadvertent errors or omissions or non-compliance? If there is, how do you rectify that? How do you manage the risk when, for example, under the Enhanced Integrity Act, the ATO is now giving to the Department of Home Affairs everybody's tax file numbers, temporary and permanent visa holders. It's not just your temporary visas. So there are so many risk and compliance, which encourage it. The aim of this is to encourage you to really create a risk resilient business that you lead if you're in a position of management and control, or that you escalate to your board so that your board escalates these to others. And if we can therefore work with you and to identify matters which may be relevant to your risk, then at the end of the day, you're going to achieve what you want to achieve, and that is the visa and the ongoing access to the program. Now, we've got still a little bit of time. If there are questions that people want to ask, we're available to you. But otherwise, there are lots of opportunities moving forward. And as Ben has said, the next webinar is payroll compliance and end of year readiness, which is on the 18th of May 2021. Please feel free to reach out to us. You can also email us directly, Rebecca and myself, in regard to the webinar. Hopefully you found this overview of some insight in regard to the priorities of the Australian government at this point in time. Watch this space so we can continue to share with you things that are relevant to how we can best help you. Thank you very much for your listening.
Thank you, Maria. Thank you, Rebecca. That was a fantastic overview, more than an overview. There's so much detail in there. It's really rich and really highlights the complexity in this space and the challenges that organisations and employers face. As I said at the start, and Maria just touched upon, I don't think we've had any questions that we can deal with right now come through. So please do feel free to reach out to Maria, Rebecca, or myself with questions on any of the issues that we have touched on today, or really any of the other things that you've heard from us in the past. Maria mentioned also, and I mentioned at the start, that our next webinar in this particular session around working in Australia is going to be around those payroll compliance and year-end readiness issues that I touched on really briefly at the start. We are also launching a separate webinar series to really focus on risk and compliance in this area, as Maria said as well, because it is so complex and fast moving. But I think with that, if I can just thank our panel members one last time, and thank you all for joining us for this session. We will hopefully see you in a month. Thank you, everybody.
Thank you very much. Bye.
Thank you.